together with accused number 2, Haji Obey Butale, together with accused number 3, Captain Dennis Yahola. None of the prosecution this morning is ready to proceed with this case as was earlier directed by this honorable court. And we have one witness ready for this honorable court. My Lord, we would humbly pray to be guided in the representation as it stands on that side.
My Lord, my name is Emmanuel Baguma, and I'm here together with Counsel Sewambala Julius, present here, and Counsel Awedo Sarah. My Lord, who are appointed by court to represent all the 3 accused persons on state brief. My Lord, Namaweje Sylvia Ebitu, Sewambala Julius, and Awedo Sarah. My Lord, were appointed by court to represent the 3 accused persons on state brief. Yes, I will proceed to go to the 0 prisons to interface with the 3 accused persons. The 2 accused persons, the one, Kizza Besigye, and Emmanuel Baguma, declined to interface with us. We were able to interface with Captain Ola, Benish Ola, who instructed us to represent him on state brief.
To the lawyers of the state brief and confirm court that truly you met them and you are ready to be represented by lawyers of the state.
I see they will have to represent me alongside my 2 other lawyers. That is Counsel Simon Supuga and Counsel Anika Namabu.
The others, there's 2 or 3, the other way.
There are 2.
Why they are not here, if you have agreed that they bring the case.
I have not been able to meet him, but I made a call on Monday. He had promised me to visit me yesterday, but he had given me a complaint that he had tried to access me. So I didn't see him until I met him then. make it.
These precautions that is A1 and A2 in the issue of the legal representation, specifically, I want the answers on the three options which were given by this honorable court in respect of the legal representation. One, I need explanation on, we'll start with the choice of the lawyers you saw which were initially in this matter, and I gave you again another chance, two of you, to assemble those lawyers. I need the answer to that. And then from there, we shall, if we still have a challenge, we shall proceed to another option given by court of the selection of lawyers of your choice from the list available to you of the state relief. And finally, I will get explanation on the representation by the three lawyers who are appointed by this court in the case we get a challenge from first and two. I will start with A1 to give me explanation of the first choice of the lawyers.
Good afternoon, Mr. Judge.
Good afternoon.
When we were last in court, on the 15th of this month, on the 15th, that's when we were last here. It's true that we were given those three approaches to solving our legal representation challenges. The lawyers we had chosen had great problems that would be resolved by our application number 248, which that sitting indicated the deputy registrar would communicate to us its fate. The deputy registrar did communicate to us. The effect that the application had been assigned Justice Simon Peter Chinove, by the principal judge. And he attached directions that had been issued by the said Justice Simon Peter Chinove regarding the disposal of that application. Which gave dates for the various activities in disposal of the application. And he indicated he will be issuing his ruling in the application on the 13th of August. Considering that we had challenges of managing that particular application from prison, we are also in the process getting assistance of some lawyers to help us. So that application is now on course. If it is successfully resolved as we hope it will, then the question of state-funded representation would not arise. Regarding the selection of state-funded lawyers, confirmed to court last time that we had received the roll of advocates on state-funded representation. Of 786 advocates. Considering the third option you are talking about, the appointment of these three, I asked a specific question. As to whether it meant that we were now represented, since they were introduced as having been appointed. Because that would conflict with number 2 of our own selection amongst the row of lawyers. Cannot be selecting and others are already appointed.
Have you selected?
I'm coming. I'm just talking about what to select from.
Yes.
Because I asked about these three, and you said
That is the third option.
I'm bringing it up in the second because I asked whether we are now represented.
I'm saying this is the third option, let me get your response on the selection of your choice.
I
Then
am-
you will come
I
to
am-
decide.
That's exactly what I'm doing.
Yeah.
I'm only saying that when I asked whether we are now represented, you said no. They can send us their CVs, the three can send us their CVs so that they are considered alongside all the others in our selection. Indeed, their CVs were sent to us. We have since reduced the numbers of lawyers to select from, the 780, 227, those who are in Kampala.
And now it is coming.
227 the state-funded lawyers who practice in Kampala itself. We have eliminated all those who are out-country. And so we asked our friends and relatives contact these 227. We equally receive their CVs. Indeed, consider them alongside the three that we received earlier. Unfortunately, greatest number of people have written CVs that simply talk about their qualifications.
Those 227.
Yet the ones we haven't received from all the 227, but the ones we have received, including the ones of the 3 here, they basically talk about their qualifications. And the firms they have worked with, the legal firms they have worked with. But nothing to do with the cases they have handled that would guide us as to their competencies relevant to our case. Of these three, indeed, it was only Sylvia Namaweje whose CV touches on that, on cases she has handled. All the others, look, I have a certificate in a out of board settlement, I have a certificate in pre-bargaining, I have a certificate in this and that. He worked in this firm, but nothing relating to the expertise and experience of representation of cases like the one we face. As I pointed out the last appearance, the charges we face are some of the gravest charges one can face, and complex in nature. And that's why we are making every effort to select advocates that would be comfortable and equal to the task. So, Mr. Judge, I wish to report that we have made a lot of progress, but we have not concluded. This process yet. And we were shocked indeed when we were informed that the three lawyers were in Rosina to meet us. They wanted to receive our disclosures so that we discuss them. And we thought there was really a misunderstanding. So, Mr. Judge, there are two things now. One, the resolution of our application 248, which should resolve our legal representation challenge conclusively. And which is clearly our preferred option. We selected those lawyers very deliberately. They were doing a good job until they were interfered with. We believe that it's our fundamental right to be represented by lawyers of our own choice where we can. So it's our prayer that God gives us time to resolve that application before reverting to the other options. Should there be the unlikely event, a persisting problem of legal representation, as I have said, sir, we are advanced in our process of selection from the role that we were given. We believe that maybe in another 1 week we will be able to identify the specific names we are comfortable with. So, sir.
For the record, Thomas Jafiko, Assistant Deputy. Beginning with accused number 3, I wrote the prosecution has had that we agrees to proceed with the 3. The prosecution has had that accused number 3 is willing to, has agreed to proceed with the 3 state brief lawyers who were selected by this honorable court. And my lord, these same 3 lawyers were selected as well for A1 and A2. And my lord, it is in fact from A1 and A2's own submission that they declined to meet these lawyers, nor have we got any confirmation of recusal of the other lawyers who are representing A1 and A2. It is the prosecution's prayer that in cases of this nature, the accused persons ought to be represented. And the state has gone ahead to have these lawyers selected, and therefore the need for another week or 2 does not prejudice this case from proceeding with hearing this morning with the prosecution's first witness. We humbly pray that this honorable court be pleased to permit the prosecution present its first witness as earlier prayed by all. My lord, otherwise this case has taken long and it may never take off, my lord.
For the interest of justice, to let you know that for the interest of justice, you will respond. I'm saying that for the interest of justice and to preserve the fairness of this fight, I will explain to you that you have a constitutional right for equal representation, and that the Constitution makes it clear, in fact mandatory, that some cases of this nature, like this one, capital cases, there must be equal representation. I listened to the challenges even today and before, which have been put forward in the legal team of your own choice. Indeed, this one is provided under Article 28 3D. But you went ahead to say that your team had challenges, and the court went ahead to advise that you can select from a list of lawyers of state belief, of which you have said that still you have a challenge of selection, but you are working on it. Now, I want to clarify on the third option of being represented by the three lawyers of state belief, that it is a legal requirement in capital cases like this one. So the Constitution requires that provision. So as you respond to what the state has said, I wanted you to know that is a constitutional requirement. So you can now respond and specifically dealing with this.
Yeah, I would like to start with the question of the delay of this case, which keeps on coming from prosecution. Since they don't tire, repeat the pretense that they want this to be solved quickly, I cannot tire, or we cannot tire, in reminding prosecution why this case has delayed. The cause is entirely the state. From the months we spent in an illegal court of the court martial, it was the state taking us there. From the time the court martial was conclusively dismissed, I went on hunger strike. I nearly died in order to be brought back to court. We were in limbo. Up to now, people who were charged by the court martial that was conclusively declared unconstitutional, they are still with us in Rosira, have not appeared before any other court, are not under any remand of anybody. They are in limbo. If I hadn't gone on hunger strike, it would have been like those. Hundreds who are still in Rosira, held by the court martial that was declared unconstitutional. Some are even now being taken back to the current court martial.
Kindly submit for your case. Those ones also submitted.
They have no chance.
You want to see their lawyer?
Since, no,
I'm guiding that let us now down to this case before this one.
maybe you want it.
Maybe
So-
that one also.
So the delay
Yes.
in our case has been occasioned by the state. They were supposed to give us disclosures last year. Even on the, was it the 15th, when we were last here, they gave us the last disclosure. They said they had finished the disclosures. They gave us two while we were here in the last court. And they told the court so, that they had brought new disclosures. Seven months later, the time we spent under the application of hiding witnesses with identity was not our making, it was the application. So all we simply ask is not to delay our own case. We are in prison. We want to get out. All we ask is that the process should be fair. Not just fast, but fair, as required by the Constitution. Having said that, sir, the state-funded lawyers is an entitlement in capital offenses where the accused cannot have a lawyer of their own choice. Even in the Constitution, it is 28(3)(d), which gives the accused the right to get a lawyer of their choice. Following that, E, and that sequence is for a purpose where that legal representation is not available of your choice. You are entitled to one by the state. Our own choices are still available. They have not gone away. It is the state that interfered with them. Arrested, tortured, deported. It is the state. and that's why we insist on solving that problem through our application to 48 as the first priority. But having said that, sir, I would expect prosecution to be familiar with the rules that relate to state-funded lawyers. That's statutory instrument 55 of 2022. In Rule 13 of those rules, which is about duties of state-appointed advocates, Rule 4, Rule 13, says a state-appointed advocate shall B, provide written confirmation to court that he or she has met the accused person within 2 working days after the meeting. And more importantly, C, submit to court a certificate of trial readiness within 5 working days before the hearing of the case in the form set out in Schedule 2. So even if these were our lawyers, we have to meet. We have to consent to them being our lawyers, which is also part of the rules. And we have to prepare for the hearing. We just don't turn up with a witness. Because Rule 14 says that at the first hearing, where we are not yet, the accused has to confirm to court whether he accepts or rejects the state funded lawyer. But in all this, I'm saying, even if lawyers of the state were to be appointed, there is a process before we can be ready for hearing. The court has been told many times before about the voluminous nature of the disclosures which we will have to go through with our lawyers, either our preferred lawyers or state lawyers, whoever they are. We will need still time and the facilities which we have been through, go through the disclosures and be ready for trial. Lastly, sir, I wish again to draw your attention, sir, that I wish to draw your attention again to the application for stay of criminal case number 355. Pending our appeal in miscellaneous application number 227.
This has a application number.
227. We hope that that application too will be heard by the court. Before hearing can take place. Thank you, sir.
I have listened to the concerns and reasons given by the co-attending persons, that is A1 and A2, and the reply from the state in respect of legal representation. For the interest of time, I'm going to use a few minutes to write a brief ruling or a summary ruling on the legal representation, especially after explaining to the accused persons the constitutional position. So give me some few minutes I make my ruling on that issue. To summarize the ruling on legal representation, I will avail both parties a detailed ruling later, but this is the summary. I have listened carefully to the reasons given by the two accused persons, specifically A1 and A2, in respect of their legal representation. This honorable court went ahead to explain to the accused persons the legal requirements by the Constitution on the issue of legal representation. Briefly, and to be specific, the accused persons, in their explanation or in their reasons they advanced to this honorable court, they told the court that they have since filed miscellaneous application number 248 of 2026. And this application will sort out the issues or the challenges of the legal representation. The persons went ahead to tell the court that the said application is now before Honorable Peter Chinodi, who has since given directions in the said application. In addition to the application which is pending, which we have advanced, the accused persons told the court that they have since looked at the list of lawyers on state brief, which was 786, and they have reduced the selection 227. They are waiting for their friends and relatives to guide them in the competence of those lawyers so that they are able to select themselves. In my view, the accused persons were given opportunity to assemble the lawyers of their choice as per Article 28, 3D. This opportunity was permitted since last year. I can say as far as 1st September, when this matter was fixed for pre-taking, court permitted the accused persons to use lawyers of their own choice as per that Article 28, 3D. It should be noted that this honorable court, even at this stage, has never at all blocked the accused persons to use lawyers of their own choice. Court has listened to these challenges, but I want to comment on still on the reasons given by accused persons today and before. The accused persons, specifically A1 and A2, on several occasions have told the court that their lead counsel, Massa Karua Senior Counsel, was deported. The accused persons have several times told the court that their other counsels, that is counsel who are for areas, was arrested and charged. It is now in prison. However, upon perusal of this court record, there are other lawyers who used to appear in this case and were representing the two accused persons. And these other lawyers, the accused persons told the court that these lawyers were intimidated and harassed. Hence, they cannot appear in this honorable court. I want categorically stated that the said lawyers, those ones who are saying that were intimidated and harassed, from the court record, I was able to notice that in this case, Counsel Ernest Karibala, Counsel Frederick Mpanga, Counsel Katumba Apple, Counsel Eru Chiza, Counsel Wanda Ronald Samuel, Counsel Proscovia Pundia, Counsel Brian Turunawe, and Counsel Kakuru Tumsini, to mention but few. Those lawyers are on record as lawyers that have been representing this two accused persons. The record still has the 13 law firms representing the accused person. At this point, I want to note that out of 13 law firms, there is one law firm which had a courtesy to notify court that they decided to withdraw the instructions. This law firm is Aruto Advocates. They wrote and notified to this honorable court on the 8th July, and it was received on the same day. It's very clear that this law firm indeed followed the process and the best practice as officers of the court to notify this honorable court they are withdrawn. I want to note that while the accused person is said, other lawyers apart from Karua who was deported and who is in prison, I want to note that other lawyers whom I have mentioned have never at any given point as officers of the court notified this honorable court that instructions were withdrawn from them or they have ceased to be lawyers in this case. I'll go ahead and state that still court went ahead and advised the accused persons that assemble those accused persons who were not reported or arrested to come and participate in this case. But the accused persons keep insisting that they are intimidated. But from court record, apart from what I'm hearing from the accused persons, these lawyers whom I have mentioned have never notified the court such intimidation or withdrawal from this case. Court went ahead and advised and explained that for the interest of justice and for the fair trial, the accused persons were given a list of lawyers, 726. I'm happy that the accused persons have told court that they have looked at them. So far they are 227, from whom they intend to select from. But in alternative, and for the interest of the time these people have been in remand, and for the interest of the fair trial, court had given third option. This third option was the court registered to appoint 3 lawyers on state behalf to handle this case. Indeed, the 3 lawyers have told the court that they went to Museum and they were able to meet A3 who went ahead to give the written instructions. This has been confirmed indeed by A3, who has told the court that the team of state briefs will represent him together with his other 2, and court has no problem with it. Now, the reasons given by the 2 accused persons, that is A1 and A2, that this case should wait for the disposal of the trust application number 248. In my view, this application is before a different judge. I can't control the matter which is before another judge. But be it as may, this court still can respect the outcome of that case at any stage. I have no problem with any outcome of the application, and the court will respect the outcome. But this court cannot wait another case. That case is not a bar of this one. I have also listened that there is an appeal lodged in the Court of Appeal in another decision before me. Still, this appeal can go ahead. There is no bar that at any stage the proceedings can stay. But the matters must proceed. I explained the constitutional right, a fair trial. And in my conclusion, I will say this, that Article 28, which provides for a right to a fair hearing, also provides under clause 3E that an accused charged with any offense which carries a sentence of death or imprisonment for life be entitled to legal representation at the expense of the state. It is my view that this court has no right to deny the accused person this entitlement which is provided for in the Constitution. By this provision, the legal representation provided by court, that is where 3 lawyers were appointed in state belief, shall remain in fulfillment of this provision. The accused persons remain entitled to add any other legal representation of the accused at any stage of the proceedings. Courts are not dispensed with this provision of legal representation in cases of capital nature. Therefore, I want to confirm that this honorable court is not imposing lawyers to the accused persons whatsoever, but it is a constitutional requirement of legal representation as per the Constitution, Article 28, 3E. Therefore, the lawyers, the 3 lawyers on state brief shall remain in fulfillment of this provision. The accused persons are free at any time to add other lawyers or to deal with the lawyers on state brief. Having said that, I will now proceed to present assessors who were chosen and given to the parties for the purposes of taking the course.
Before you do so,
I will allow you, let me first know assessors, whether the 3 assessors are here. The 3 assessors. May I know whether Ms. Sarah is here? Please stand up. Let me know whether Mr. Musa is doing it. May I know whether Mr. Okelo Richard? May I know whether the state has any this? Somebody get the assessors.
My lord, do have no objection.
This is who?
Richard Billiton. My lord, Chief Secretary for Prosecution. We have no objection to the assessors.
My Lord, Emmanuel Baguma to receive the details of the three assessors, and we have no objection to them.
I want to confirm from S3, the chief assessors. Let me hear from A1, the assessors.
Yes, I have a problem because we are given their details during the period we have not been represented. As I pointed out, we are in a prison, within a prison. We are not yet in any position to ascertain the information pertaining to the assessors one way or another. Even if we were to rely on state-funded lawyers, as you have just asserted, we would need, first of all, meet with them and to go through all these together. We have not been in any position to meet any lawyer, state-funded or otherwise. So clearly, we are not in a position to say anything about their suitability as yet.
same opinion. Clear one.
A bit of this one report. This is another opportunity to you, doctor, and I want to hear from you that if you are given opportunity right now to meet the lawyers on state brief and the assessors, I think we are not watching the football match. We are in court. I am appealing to the public, the people in this honorable court, that you must provide conducive environment in this court. I'm asking you, Doctor, that if you are given opportunity to meet now, these lawyers make history. They have disclosure. You recollect had a disclosure. I'm asking you as the last chance that would you mind meeting them, given some time, and then with the assessors whom you accepted that you got the list, would you take that offer to give you some time in the court here, even if it is a different court code? Can give you a different court code and we agree on the time to meet them and then we come back here. What is your take?
I will still have a problem with that. I actually have a problem with that. Because, like I pointed out, even if these have been appointed to be our state-funded lawyers, the laws provide the process through which they become. They don't instantaneously become because they have been appointed. And I refer this court to the rules. Starting instrument 55, 2022. So, before using them to achieve purposes on our behalf, we would have to first of all meet with them, and establish whether we consent that they become our lawyers. Which is a process that we will be open to. But even before that happens, to now say meet with the assessors and get the lawyers use now, establish the suitability of assessors. Again, clearly not in line with the dictates of fair hearing. So if the court so feels, it can go ahead and appoint them without our participation. But I cannot participate when my eyes are tied, closed. I have to participate with free hands and free eyes and minds.
Your Lord, I want this to be on record. We don't fear to be tried. But what we're looking at, all we want in this type of justice is fairness. So I cannot associate myself with the assessor whom I don't know. That's all.
This honorable court has already pronounced itself in the issue of legal representation in the summary ruling which I have just given. And the detailed ruling, as I said, it will be available to the parties. For the issue of assessors now, the 3 assessors were chosen a long time ago from the 6 assessors, and their CV was given to all the parties, indicating their details. And from that time, there is no party who came up with any concern about the assessors. Section 69 of the Trial of Indictment Act provides for the challenge of the cause before an assessor is formed. The challenge of the assessor for the cause, the grounds are provided for under section 69, 1, A, B, C, and D of PIA. The Constitution and the lawyers on state leave, together with A3, have told the court that they don't have any objection to the 3 assessors, save A1 and A2. I have reported the reasons given by A1 and A2 in respect to the assessors. Having listened to them, I looked at section 69(1) D, A, B, C, and D. The reasons advanced don't fall within the ambit of the challenge under that section. In the view of the above, I direct that the 3 assessors take the position. We shall establish this.
Say in the name of the Almighty God, that we say about the name of the Almighty God that I efficiently advise this honorable court on the matters pending before it to the best of my knowledge, skills, and ability. So help me God.
Musa and John, do swear by the Almighty God that I shall be efficiently apply this honorable court in all matters pending before this honorable court, to the best of my knowledge, skill, and ability. So help me God.
I, Colonel Richard, do swear by the Almighty God that I shall efficiently advise this court in all matters pending before this honorable court to the best of my knowledge, skill, and ability. So help me God.
This court has witnessed the swearing in of the civil assessors and is approved. Produce your witness here. Produce your witness here. Yes, I'm saying produce the prescription.
The witness was just Yes, my lord. For the record, Thomas Jatiko, Assistant DPP. My lord, from where the witness was waiting for this other court is being brought any minute.
How many minutes do you want?
No, Melody is just about 2 minutes.
Okay. Yes, we said you want to say something?
Yes. First of all, I take it that you are ruling, also issued a ruling in our application 269. My understanding is that your ruling issued, made a ruling also on our application, which is before this court.
Which one?
Application number 269, application for stay.
What are you saying about it?
Have you made a ruling in that application within the ruling of our lawyers?
Which application?
There is an application before this court for stay of criminal case number 355. Pending.
That's good. You want to know whether my ruling, this ruling I have made.
Yes, there is an application before this court. Number 269, seeking stay of criminal case 355.
Application number
269.
269
Yes,
2026.
yes.
You said for stay.
For stay of criminal case 355, pending appeal. On the ruling of application 227. question is whether it has been ruled on without being heard.
Has never been fixed and is not coming today, the same application will be handled on its own merit. Let us proceed with that.
I still have another question.
Kindly, no.
I have another question.
No.
No way.
I'm saying
I am here to seek justice. This cannot continue.
prison.
I'm already in prison. I am already in
This
prison.
person in order.
No.
You will not dictate what the process.
Am I represented? This is a matter which is constitutional, which is fundamental.
Can we
Has any of these people met me? Can they represent me without meeting?
can you lead court its own?
Yes,
Court is not
my
doing what?
lord, before record, my name is Richard from Boka, Chief Secretary for Prosecution, and I will read the witness. So, can you tell this court your name and your region?
We cannot continue without representation. It's simply criminal. It's not going to happen.
Cannot interfere with court process.
There is no court process. This is a criminal process. It's not a court. I've read you the laws. Which laws are you following? If you can't follow the laws of Uganda,
Can you give the court?
court is proceeding to do wrong things in my view. It's my duty as a citizen to stop it.
Can we proceed?
Can you tell this court your name and your region?
My lord, my name is Andrew Wilson, and I'm an Orthodox Christian.
The religion? One country.
I'm an Orthodox Christian.
Please take part.
Let me capture the names properly.
Orthodox Christian.
Continue to try your I will not stay in this hopeless court. I will not. You can continue to try me in my absence. I will not continue with this criminal record.
Order you to stay, whether you want to listen or not. Stay.
I will not stay. I will not stay.
So the reason we get done.
I will not stay. And if I stay, you will not conduct the court. You will not conduct the court. These criminals cannot come and take over our country. You will not conduct the court. I will not allow it. I will not allow injustice to continue. We shall not allow it. I will not allow it, Mr. Baguma. No way. No way. No way. We shall not allow this nonsense. It's not allowed. You have abused our country now. You have abused our country now. Stop it, you. Stop it.
No.
I will not allow you to continue
I am
abusing our country, abusing our constitution, abusing the laws. I will not allow you in your family. I will not allow you.
If you don't want to sit,
I-
go out.
No.
The other people. Court order. Whoever doesn't want to sit, then go out.
We will not allow this. We will not allow this. Don't tear my papers.
Don't want to sit, court order.
Eh? Stop it. You can take me out, but you won't keep me here. Why? I will not keep you quiet.
Those papers.
No way. You can take the papers. They must take my mouth also. My mouth will continue talking. I will say you are raping our constitution. You are raping our courts. You are raping the law. We shall not allow this. It has to have a stop. It has to have an end. It has to have a stop. We shall not allow it. We shall not allow it, yes. I will make an alarm for the whole. We shall, everything must have a stop. We must stop it. You cannot continue raping the Constitution. No way. You will not rape the Constitution. And we allow it. We fought to establish a Constitution. We went to war to fight for the Constitution. The Constitution that Mr. Museveni and his government are raping right now in this court of Mr. Baguma. We shall not allow it. We shall not allow. We shall not allow. You are injuring me, you prisoners man. You are injuring me with your handcuffs. You are injuring me. You are injuring me. You are injuring me. Why are you holding me? Why are you holding me? I am in court. I am not violent. Why are you holding me? I am simply stopping an injustice. Stopping a raping of the Constitution. Saying they should not continue to rape our Constitution. Mr. Baguma, everything must have a stop. We fought to make sure that it is the rule of law. When people died, 500,000 people died. 500,000 people died. Yes. Get the Constitution. We cannot stand by and let that Constitution be raped by Mr. Baguma and his court. No way.
You say you yes, what? What did you for?
Stop abusing our Constitution. Stop raping our Constitution. Stop abusing our country. Stop bringing these criminals to abuse our country. Stop it. It must stop. This must stop. The country must stop. Must stop these criminals. The country must stop abuse of our laws, abuse of our rights, abuse of our Constitution. This must stop. 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 This must stop.
Yes, you said
this must stop. 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 This injustice must stop. This must stop. This must stop. This injustice must stop. This must stop. This must stop. We can keep quiet and seeing these criminals. We can't let the criminals off. We shall fight them. We shall not tire. We shall fight. We shall fight. We shall not allow this. We shall not allow the abuse of the law. We shall not allow the Constitution to be abused. We shall not allow illegal trials. We shall not allow Mr. Baguma. You are a nuisance. You are abusing our Constitution. You are abusing the law. You are abusing these courts. These courts must refuse this. We must.
Private security.
These criminals should be stopped. Criminals must be stopped. Abuse of our constitution 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 must be stopped. These must stop. These must stop. These must stop. Criminals must go. These must stop.
You know why?
The constitution must be stopped. The court must be stopped. Court must be stopped. Okay, now let me out. Let me now go. Let me go. You cannot hold me court. Let me go. Let me go. You cannot give my justice. You cannot allow this. You must allow me to leave court. Allow me to leave court. You cannot allow, cannot be in court going on like this. We must fight.
Yes.
We must fight. We must fight. We must fight for our constitution. We must fight for our rights. We must fight the Bagumas who are raping our constitution. We must fight. 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 We must fight for our rights. We must fight for our rights. We cannot allow raping of our constitution. Mr. Museveni and Mr. Baguma, the rapists of our constitution. This must stop. This must stop. This must stop. This must stop. This must stop.
Who introduced you?
Joe Wacky, who was
What?
I was introduced to Dr. Kizza Besigye, that overthrow the government, assassinate the president.
So after by Joy Wakanda.
There was a series of meetings in Athens, Nairobi, where we discussed plans to open Uganda. started in September 2001 by Joe Wakiki.
When did you start having these meetings? Wait, okay, wait.
Dr. Besigye,
Abuse of our constitution. Abuse of our rights.
the reason my Lord
Rape of the constitution. Rape of the constitution. Rape by Mr. Baguma.
Just a minute.
Rape by Mr.
You said
Baguma.
you met him on the
Rape by Mr. Baguma.
23.
Rape.
Yes.
Where?
Rape.
And that was in the center of Geneva, close to the train station.
How can you hold me here against my will? I have a right not to be in this court. I have a full right by the constitution not to be in this court.
So what happened after renting that apartment in Missouri?
I met with Joe Wakiki and Frank Kahiri on September 28th. Dr.
So who attended?
I attended the meeting, Joe Wakiki attended the meeting, and also Frank Kahiri and Dr. Besigye attended the meeting.
When was
It was on the 29th of October.
That's what is when I was down a long time ago. Stop nonsense. Stop this nonsense.
So what happened in that
Stop.
In that meeting, we discussed how Joe Wakiki and Frank Kahiri and Dr. Besigye
You are trying to
planned to overthrow his government.
No way. Take me out if you
Discussed
want
in that
to stop.
meeting
I will not stay in this hopeless
the
court.
relevance of Bob
This
Wine,
hopeless court.
how to inject currency into the Ugandan
hopeless court.
government.
Must be stopped.
I provided
The
Dr.
hopeless
Besigye
court must be stopped. Abuse of the constitution must stop. Abuse of the constitution must stop.
Let's be slow.
Abuse of the constitution should stop. Stop.
You said
Stop.
you discussed the plan over
Stop.
the government of the Republic of Uganda.
Stop.
With who?
Stop.
With Dr. Kizza Besigye, with Frank Kahiri, and Joe Wakiki.
But
helping somebody who is corrupting.
These are doctors.